The Texas Supreme Court is deciding what to do about a Texas judge who refuses to marry same-sex couples. This is about Waco Area Justice of the Peace Diane Hensley. She has refused for years to officiate marriages for same-sex couples. In 2019, the State Commission on Judicial Conduct disciplined Hensley, saying that refusal amounts to discrimination, violating her oath to uphold impartial justice. She filed a lawsuit arguing the state's religious freedom law allows her to adhere to her faith while practicing as a judge. On Wednesday, attorneys argued the case before the Texas Supreme Court.
He has chosen to discriminate between some folks in the state of Texas in favor of other people. And it flies in the face of impartiality.
It's not unconstitutional to believe that marriage is between a man and a woman, and for your belief to come from the Bible. And it also shouldn't disqualify you from being an elective office or from being a judge.
Capitol correspondent Ryan Chandler covered the case. Ryan, isn't the issue of gay marriage settled already by law?
You would think so, Josh, dating all the way back to 2015 when the Supreme Court said gay marriage is legal in all 50 states. But what the defendants in this case are trying to do in front of the Texas Supreme Court is target, I think, two U.S. Supreme Court decisions. The first one is a case from earlier this year, actually, which allowed a Colorado web developer to refuse to work with gay couples, essentially allowing her to refuse to make marriage websites for same-sex couples. They want to expand the reach of that and say that that kind of deference that they gave to the web developer should apply to this judge as well. But I think also they're going back to that 2015 Obergefell decision and trying to say that while they did legalize gay marriage, they left room in there for religious liberty. And if a judge in this case has a sincere objection to marrying gay couples, then that should not preclude them from doing their work as a judge.
Now, normally when someone sues Texas, the Office of Attorney General represents the state, and that didn't happen this time, though. Why?
Well, this is actually nothing new. The Attorney General has made his name by suing the Biden administration and the federal government chiefly, but another often forgotten but very important part of the Attorney General's job is to defend state agencies when they get sued. The Texas Tribune reports, though, that within the last 2 years alone, Ken Paxton has refused to represent state agencies 75 times, and a lot of those are on ideological grounds. Say if a university is defending itself in an affirmative action case, or if another state agency is being sued by one of Paxton's political allies, he will simply refuse to represent them and make that state agency get private counsel. It's important to remember, though, that when that happens, the taxpayers are still paying for that representation. It's just with a private firm, often for a price tag that may be even higher than what the Attorney General's office may cost the taxpayers for that counsel.
Well, when can we expect a ruling in this case?
I spoke to the lawyers about that this week. They say it could take some time, but they're hoping to have a resolution during this court's term, which goes all the way until June. So we could be waiting on an answer here for a while.
All right, Ryan, thank you very much. Lieutenant Governor Dan Patrick makes a $3 million decision. How reports about anti-Semitic influences fueled a big move tied to a controversial campaign donation. Texas families losing options for childcare. We dig into the data to see what's behind the troubling trend.